Did medieval women have no voice? Was their fate always decided by men? Did they never own land, never control wealth, never fight for their rights? Step back to a world stretching from the 11th to the 15th century, a time far more complex than the stories often told. Number 5. The legal chains that never were. A common story suggests that medieval legal systems universally bound women, denying them any access to property or inheritance without a single breath of relief or deviation. This narrative paints a picture of uniform oppression, an ironclad set of rules applied without mercy or regional difference. Yet the sprawling, intricate tapestry of medieval law, custom, and practice tells a vastly different story. The very idea of a single, monolithic legal system across Europe, let alone one that applied identically to all women, misses the dizzying diversity of the era. From the chilly fjords of Scandinavia to the sun-baked plains of Iberia, from the bustling markets of Italy to the quiet manors of England, the rules governing who inherited what, and under what conditions, shifted and changed like the seasons. In England, the common law certainly favored primogeniture for landed estates, directing inheritance to the eldest son. However, even within this system, exceptions and alternatives provided avenues for women. Dower, for example, was a fundamental right for a widow. It granted her a life interest in 1/3 of the lands her husband had possessed at any point during their marriage. This was not a gift, it was her legal right. And Elena of Thorn, whose husband died in 1320, successfully claimed her dower lands, which included a manor house, several fields, and a small wood. She managed these lands, collected rents from tenants, and even brought cases in the royal courts to protect her interests against neighboring lords who encroached on her dower property. She was not a passive recipient, she was an active landholder, a financial manager, and a litigant. The court records of the time show countless women like Elena pursuing their dower rights, sometimes against the resistance of their late husband's heirs. The system provided the right, and women seized it. Beyond dower, some English boroughs and manors operated under local customs that differed significantly from common law. The custom of gavelkind, prevalent in Kent, dictated partible inheritance, meaning land was divided among all sons, and sometimes even among all children, including daughters, if no sons were present. In some Kentish boroughs, women had an even stronger position. In Canterbury, for instance, a widow could inherit half of her deceased husband's burgage tenement town property in fee simple, meaning outright ownership, not just a life interest. This gave her full control to sell it, lease it, or pass it on to her own heirs. Agnes of St. Peter's, a Canterbury mercer's widow in the late 14th century, inherited her husband's shop and house directly. She continued the family business, traded textiles, and was listed in the borough records as a property owner and taxpayer, wielding economic independence within the urban environment. This was not a universal norm, but it was a vibrant reality for many women in specific localities. Moving across the English Channel, the lands that would become France presented an even more complex tapestry of legal traditions. The South, influenced by Roman law, often saw different marital property regimes than the North, which developed its own customary laws. In areas influenced by Roman law, dowry was a crucial element, but it was generally considered the wife's property, managed by the husband but ultimately destined to return to her or her heirs. The marriage contract for Isabel of Toulouse in 1280 specified a substantial dowry of money and lands. While her husband administered these assets during their marriage, the contract explicitly stated that if she outlived him, or if the marriage produced no children, the dowry would revert entirely to her. She used this wealth after her husband's death to establish a charitable foundation and provide for her nieces, demonstrating her independent control over significant resources. Northern French customary laws also varied greatly. In some regions, a community of goods was established upon marriage, where both spouses' premarital and acquired assets merged into a common pool, jointly owned. Upon the death of one spouse, the surviving spouse often had a substantial claim to this community property. Jeanne, a Parisian baker's widow in the 1300s, continued to operate her husband's business, which was considered part of their communal property. She appeared in court records as a defendant in a commercial dispute, demonstrating her legal standing and her ability to conduct business independently after her husband's passing. Her right to manage the business stemmed from her half share in the community of goods, a testament to specific legal frameworks that empowered widows. The German lands, a patchwork of duchies, free cities, and ecclesiastical territories, showcased an extraordinary range of legal customs. Urban centers especially often granted women more autonomy than rural areas. In Cologne, a thriving mercantile city, married women could sometimes own property separately from their husbands, engage in trade independently, and even act as guarantors for debts. Bertha of Cologne, a merchant's wife in the 12th century, bought and sold property in her own name, a practice recorded in the city's commercial registers. When her husband died, she continued her business, inheriting his trade contacts and assets according to local custom, which allowed for a greater degree of female economic agency. This was a far cry from a universal system that denied all women property rights. In Italy, particularly in the northern city-states, the legal landscape was shaped by a blend of Roman law, Lombard law, and local statutes. Dowry was paramount and was almost always considered the wife's property, administered by the husband, but with clear provisions for its return. Venetian women, particularly those of the merchant class, often had significant control over their dowries and even separate assets. Caterina, a Genoese widow in the 14th century, not only reclaimed her substantial dowry after her husband's death, but also used it to finance her son's entry into a trading partnership. She was a shrewd investor and a legal actor, fully capable of deploying her inherited wealth for her family's future, all within the bounds of Genoa's specific legal framework. Even in regions where male preference was strong, the absence of male heirs could open the door for daughters to inherit vast estates. Eleanor de Bohun, a powerful English noblewoman in the late 14th century, became a co-heiress to the earldom of Hereford, Essex, and Northampton, one of the wealthiest inheritances in England, because her father died without male heirs. She inherited significant lands, castles, and revenues, which she held and managed independently. Her story and the stories of countless other heiresses across Europe demonstrate that the lack of a brother, rather than the existence of a restrictive universal law, often determined a daughter's path to a substantial inheritance. These women were not mere pawns. They were often formidable figures, managing vast resources, engaging in political maneuvering, and even leading their own retinues. The reality was that medieval law was not a single unyielding entity. It was a mosaic of local customs, royal decrees, church canons, and ancient traditions, constantly evolving and often contradictory. Women, whether noblewomen managing sprawling estates, urban craftswomen running businesses, or peasant women inheriting small plots of land, navigated these complex legal frameworks. They used the specific provisions available to them, whether it was dower, dowry, borough custom, or the simple absence of a male heir, to secure, manage, and even expand their property and economic interests. To claim a universal legal oppression regarding inheritance for all medieval women across all social strata and geographical regions simplifies a rich and multifaceted history to the point of distortion. The legal chains where they existed were often specific to place and circumstance, and in many instances they were surprisingly flexible, allowing women to act as property owners, managers, and economic agents in ways that defy simplistic narratives. Number 4. The destitute widow fable. The narrative of the medieval widow often paints a bleak picture of a woman stripped of her status, left penniless, and forced into utter dependence, her fate controlled by the whims of her late husband's family or the charity of strangers. This image of the universally destitute and powerless widow is a persistent one, yet historical records, legal statutes, and countless individual examples reveal a profoundly different reality. While widowhood certainly brought challenges, for many women it marked a period of increased legal autonomy and economic power, offering a freedom they might not have possessed during marriage. The status of a widow in medieval society, far from being one of unremitting destitution, was often defined by specific legal rights designed to ensure her financial security and social standing. In England, the right of dower was a cornerstone of a widow's economic security. As mentioned, this was a life interest in 1/3 of her husband's lands. This was not a discretionary gift, it was a right enforceable in the king's court. A typical dower holding for a noblewoman might include an entire manor, complete with its tenants, rents, and jurisdictional rights. Eleanor of Montfort, the widow of Simon de Montfort, after her husband's rebellion, faced significant challenges, but even in her tumultuous circumstances, her dower rights were acknowledged and protected by law. Though her husband was attainted, the law still recognized her claim to lands that had been her dower, even if their actual possession was difficult. The legal principle was firm. For a more typical example, consider Matilda, a knight's widow in Wiltshire in the early 14th century. Her dower lands provided her with a substantial income. She resided in a dower house, managed the agricultural output of her fields, collected feudal dues from her tenants, and oversaw the manor's daily operations. She appeared in manorial courts, heard cases, and presided over local disputes, exercising considerable authority derived from her dower holding. These activities were not unusual. They were the expected functions of a landholder, and a dowered widow was indeed a landholder. She was financially independent and socially prominent within her local community, directly contrary to the image of destitution. Beyond dower, many aristocratic marriages included a jointure agreement, where specific lands were settled jointly on the husband and wife at the time of their marriage. Upon the husband's death, these lands automatically passed to the widow, often providing her with a larger and more secure income than dower alone. Joan, Countess of Kent, widow of Edward the Black Prince, held vast estates through jointure. These estates provided her with immense wealth and influence, allowing her to live in considerable splendor, maintain a large household, and act as a significant political figure in her own right. Her jointure was a powerful economic base, securing her position as a leading woman in the realm. For urban women, particularly those involved in trade, widowhood often brought an unparalleled degree of autonomy. In many European cities, a widow had the right to continue her deceased husband's business. In Frankfurt, for example, a widow could retain control over her husband's workshop and trade, especially if she had been actively involved in the business during his lifetime. Anna, a cloth merchant's widow in Nuremberg in the 15th century, successfully continued her husband's lucrative trade. She imported fine wools, supervised weavers, sold finished cloths in the market, and managed her accounts. Her name appears in the city's tax registers and guild records as an independent economic agent, a testament to her ongoing business acumen and the legal provisions that allowed her to thrive. She was not left on the streets. She was a respected businesswoman. In Italian cities, particularly those with strong merchant traditions, widows often played crucial roles in managing their family's wealth and businesses. The system of dowry, while managed by the husband during marriage, was generally considered the wife's property. Upon widowhood, the dowry was expected to return to her, providing a significant capital base. Alessandra Strozzi, a Florentine widow of the 15th century, is famous for her extensive correspondence, which details her active management of her family's mercantile and landed interests. She invested money, managed farms, arranged marriages for her children, and corresponded with her sons abroad, offering shrewd financial advice. Her letters paint a vivid picture of a woman with considerable economic power and decision-making authority, navigating the complexities of banking, trade, and family politics. She was financially solvent and deeply involved in her family's economic future. Widows also frequently gained significant control over their children's wardship and inheritance. If a husband died leaving minor children, the widow was often appointed as the guardian of their persons and, crucially, of their estates. This placed her in a powerful position, as she managed the children's inherited lands and incomes until they came of age. Agnes, widow of a gentleman in Burgundy in the 13th century, acted as guardian for her young son. She administered his estates, negotiated feudal obligations with overlords, and handled disputes with tenants. Her actions preserved the family's patrimony and demonstrated her legal capacity to manage complex financial and landholding affairs on behalf of her minor heir. This guardianship was not a token gesture, it involved significant responsibility and authority. Furthermore, widows retained their legal standing in court. They could sue and be sued in their own name, contract debts, and make wills. This ability to engage independently with the legal system allowed them to protect their interests and pursue their rights. Beatrix, a French widow in the early 14th century, successfully petitioned the king for the return of lands seized after her husband's death, asserting her claim based on her dower and jointure rights. Her petition and the eventual royal decree in her favor underscore her active pursuit of her legal entitlements and the responsiveness of the legal system to such claims. She was not a voiceless victim, she was a legal agent. The image of the destitute widow often overlooks the substantial social support networks available to women. While not a direct legal right, many guilds, confraternities, and charitable organizations provided assistance and community for widows, especially in urban areas. These networks, combined with the legal provisions for dower and property return, meant that while life might have been challenging, outright destitution was far from universal. The prevailing legal and social structures, in many contexts, were designed to prevent it. The very concept of a widow, a femme sole in English common law, meant a woman acting independently in legal and economic matters. This status granted her rights and responsibilities akin to those of a man, freeing her from the legal constraints of coverture that applied to married women. She could enter into contracts, buy and sell property, and conduct business without her husband's permission. This newfound legal independence, combined with specific inheritance provisions, often empowered widows to become significant economic and social forces, making the idea of the universally impoverished and powerless widow a misleading simplification of a truly diverse and often resilient reality. Number 3. Daughters disinherited without exception. The idea that medieval daughters were always completely disinherited, especially if a male heir existed, paints a stark picture of gender-based inequality in inheritance. This narrative often focuses on the practice of primogeniture, where the eldest son inherited all or most of the family's landed estate. While primogeniture was indeed a dominant inheritance custom for noble and gentry families in certain regions, particularly England, it was far from a universal or absolute rule. Many other legal customs and social practices created significant avenues for daughters to inherit, acquire, and control wealth, demonstrating a much more nuanced and complex system of succession than often portrayed. One of the most significant deviations from strict primogeniture was the common practice of providing daughters with a marriage portion or dowry. This was not just a small gift, it was often a substantial transfer of wealth intended to provide for the daughter's financial security within her new marriage. While it might not be a share of the family land in the same way a son inherited, it was a direct inheritance from her parents' wealth. And Isabella of Hainault, for instance, brought a considerable dowry to her marriage with King Philip II of France in the 12th century, including the county of Artois. This dowry was legally her property, and while her husband administered it, it shaped the political and economic landscape of the marriage. Upon her death, it typically reverted to her heirs or was held by her husband on certain conditions. For commoners and in certain regions, especially on the European continent, partible inheritance customs were common. In these systems, land or property was divided among all children, or all sons, or sometimes even all siblings, regardless of gender. In much of rural France, particularly in the south and parts of Germany, land was often divided among all children. A peasant family might divide their small farm among their sons and daughters, ensuring that each child received a share, even if small. Marie, a peasant woman in the Limousin region of France in the 13th century, inherited an equal share of her parents' land with her brothers. She cultivated her portion, managed her livestock, and paid her feudal dues, independently running her inherited property. This was a direct share of the family's primary asset, entirely contrary to the notion of complete disinheritance. In some urban areas, especially in thriving merchant cities, women often inherited equally with their brothers, or at least received significant shares. The city charters of places like Florence, Venice, and many German free cities contained provisions that allowed daughters to inherit property, including houses and businesses. In Lubeck, a major Hanseatic city, the municipal law often dictated that if a father died without sons, his daughters inherited equally. Even if there were sons, daughters often received substantial portions, especially in commercial wealth, which could be significant for merchants. Greta, a Lubeck merchant's daughter in the 14th century, inherited a share of her father's shipping business and warehouses alongside her brother. She later married another merchant, bringing her inherited assets into the new family, which bolstered her husband's trading ventures and her own standing. She was a co-owner of a substantial business not disinherited. The absence of male heirs was another crucial factor that frequently led to daughters inheriting entire estates. If a lineage failed to produce a son, the daughters became heiresses, often inheriting vast lands and titles. Take the example of Alice de Lacy, Countess of Lincoln and Salisbury in the early 14th century. She was the sole surviving child, and thus the sole heiress of her enormously wealthy father, Henry de Lacy. She inherited immense lands, castles, and revenues, becoming one of the richest women in England. Her marriages were highly sought after, not because she was powerless, but because she brought unparalleled wealth and influence. She held her lands in her own right, collected rents, and wielded considerable feudal power. Her inheritance was complete, not limited. Similarly, in England, co-parsonary was a legal mechanism where if a man died without male heirs but left multiple daughters, those daughters would inherit his estate equally as co-parsoners. They would hold the land jointly, though they could later agree to divide it. This meant that the inheritance was divided among the sisters, not passed over entirely. The sisters co-owned substantial estates and were each entitled to a share of the revenues and responsibilities. The three daughters of Thomas of Brotherton, Earl of Norfolk, in the 14th century, inherited his extensive lands as co-parsoners. Each sister, or her husband, then held a portion of the vast Norfolk estates, demonstrating that daughters were indeed direct inheritors of major noble patrimonies when male lines failed. Moreover, the concept of a father's disposition of property, often through a will or a deathbed declaration, could also ensure a daughter's inheritance, even if not the primary estate. While many wills favored sons, it was not uncommon for fathers to leave specific legacies of money, personal property, or even small plots of land to their daughters, especially if they were unmarried or needed support. A peasant's will in 15th century England might detail a small cottage and a few animals to his unmarried daughter, while his main farm went to his son. This was a direct inheritance, secured by legal means. The practice of marriage, while often arranged, was also intrinsically linked to the transfer of property to daughters. The dowry or marriage portion was not just a symbolic payment, it was a fundamental financial provision. It ensured that the daughter had resources within her new family and often secured her future dower rights in her husband's property. Without this dowry, a marriage might not even occur, highlighting its essential role in a daughter's financial well-being and life prospects. This was her financial stake, her economic claim to a share of her family's wealth. Finally, the church's influence through canon law, especially regarding the making of wills, encouraged provisions for all children. While not always dictating equal shares, it generally promoted the idea that parents had an obligation to provide for all their offspring. Many wills, influenced by Christian piety, made specific bequests to daughters for their marriage or to provide for their living expenses if they remained unmarried or entered religious life. These provisions, though sometimes smaller than a son's inheritance, were nevertheless direct transfers of family wealth to daughters, solidifying their access to financial resources from their natal family. The simplistic notion that medieval daughters were always and completely disinherited when a male heir existed ignores a vast array of legal customs, family strategies, and individual circumstances. From substantial marriage portions to direct co-inheritance of land, from urban customs to the crucial factor of lacking male heirs, daughters regularly inherited and controlled significant wealth. Their access to property was diverse, shaped by region, social class, and the specific composition of their families, rather than a single, unbreakable rule of disinheritance. Number 2. Loss of all wealth upon marriage. The idea that a medieval woman, upon marriage, instantly lost all control over her existing wealth, transforming into a mere appendage of her husband, is a pervasive misconception. This claim often ignores the nuance and varying legal arrangements surrounding marital property across medieval Europe. While it is true that under some legal systems, particularly English common law, a married woman, a femme covert, faced significant restrictions on her ability to manage property independently, it was far from a universal or absolute loss of all wealth. Various legal mechanisms, regional customs, and social practices ensured that women retained significant financial interests and, in many cases, a degree of control over their assets, both within and outside the marital union. In English common law, the doctrine of coverture meant that a married woman's legal identity was subsumed within her husband's. He gained control over her real property for the duration of the marriage and outright ownership of her movable goods. However, this control was not absolute ownership. For her real property land, the husband had rights to its revenues and could manage it, but he could not sell or alienate it without her consent, particularly if it was her inheritance. A woman's land remained her own in terms of title, and upon her husband's death it reverted entirely to her or passed to her heirs. For example, if a woman inherited a manor before marriage, her husband would enjoy its income during their union. But if he tried to sell it, she would have to participate in the conveyance, often undergoing a separate examination to ensure her consent was freely given, not coerced. The land was still legally hers, despite her husband's temporary management rights. Furthermore, a critical aspect of women retaining control over assets was the dowry. While the dowry system varied, in many parts of continental Europe, the dowry was considered the wife's property, managed by the husband for the benefit of the marriage, but ultimately returning to her or her heirs. In Italian city-states like Florence, a dowry was a substantial financial contribution from the bride's family to her husband, but it was legally distinct. The husband was obligated to repay the dowry if the marriage ended, or to provide for its return to her heirs. For example, Costanza, a Florentine merchant's daughter, brought a considerable dowry of money and bonds to her marriage in the late 14th century. While her husband invested and managed these funds, Costanza's family often appointed a guardian to oversee her dowry, ensuring it was prudently managed and that it would be returned to her or her heirs if the marriage dissolved or she was widowed. This system provided a powerful safety net and a clear recognition of the dowry as her property. In some regions, particularly those influenced by Roman law, there were specific legal provisions for separate property for wives, known as paraphernalia or separate estates. This typically included clothing, jewels, and other personal items that were considered solely the wife's property, completely outside her husband's control. She could buy, sell, or dispose of these items without his permission. For wealthier women, these paraphernalia could include substantial assets. A noblewoman might possess a collection of valuable jewels and fine silks that were considered her personal property, which she could pawn or sell independently if needed. This was not insignificant for some women. These items represented a considerable portion of their personal wealth and provided a degree of financial autonomy. Many urban customs across Europe also granted married women greater economic independence than common law or rural customs. In some German cities, married women could register as independent traders or femme sols, meaning they could conduct business, enter into contracts, and incur debts in their own names without their husband's involvement. Johanna, a brewer's wife in Bruges in the 14th century, ran her own separate textile business. She bought raw wool, hired spinners, and sold finished cloth, operating her accounts and managing her staff entirely independently of her husband. Her legal status as an independent merchant allowed her to accumulate and control her own wealth, demonstrating that marital status did not automatically strip all women of economic agency. Even in regions where coverture was strong, a woman's dower rights, the right to a life interest in a portion of her husband's lands upon his death, were established at the time of marriage. While she didn't possess the land until she was widowed, the right itself was created when she married. This meant that she had a future claim to a significant portion of her husband's assets, a claim that he could not unilaterally negate. This was a crucial and alienable future interest that protected her economic security. The law ensured this right, regardless of his wishes. Furthermore, prenuptial agreements, while not as common or formalized as in later periods, did exist in various forms. In some parts of Europe, especially among the nobility, marriage contracts could specify how property was to be managed during the marriage and how it would be divided upon death. These agreements could ensure that a wife retained direct control over specific lands or revenues. The marriage contract for Lady Eleanor in 13th century France detailed specific lands that were to remain entirely under her personal administration, separate from her husband's estate, with their revenues at her disposal. This was a deliberate legal structuring to preserve her financial independence within marriage. The claim that women lost all wealth upon marriage ignores the diverse legal frameworks and the specific arrangements designed to protect women's financial interests. Whether through the direct ownership of their dowries, the legal protection of their inherited lands, the control of separate property, or the specific provisions of urban and regional customs, many medieval women maintained significant connections to, and often control over, their wealth even within marriage. The legal systems of the era were not uniformly designed to strip women of all economic power. Rather, they provided a complex array of provisions that, while often favoring male authority, also recognized and protected women's financial claims and interests. Number 1. Medieval women had no property rights whatsoever. The assertion that medieval women possessed no property rights at all, that they were entirely excluded from owning, inheriting, or controlling any form of wealth, stands as one of the most pervasive and misleading claims about the Middle Ages. This statement is a sweeping generalization that disregards the intricate legal landscape, the varied social customs, and the countless documented instances of women across different social strata actively engaging with and benefiting from property ownership. While women's rights were often different from men's and varied significantly by region and social class, the idea of a complete absence of property rights is simply not supported by historical evidence. Let's first look at unmarried women. In England, an unmarried woman, or a widow, a femme sole, held the same legal rights as a man in terms of property. She could inherit, own, manage, sell, and buy land, houses, and movable goods entirely in her own name. She could appear in court to defend her property rights, make contracts, and write wills. Marjorie Kempe, the 15th century English mystic, despite her religious focus, was a businesswoman in her early life. She ran a brewing business and a milling business independently. She bought and sold grain, managed employees, and faced legal disputes. Her ability to engage in these commercial activities stemmed directly from her legal status as a single woman, fully capable of holding and managing property. This was not an exception, it was a fundamental aspect of the law for unmarried women. For landed inheritance, while primogeniture favored sons in England, daughters often inherited significant estates when there were no male heirs. The sisters of a deceased lord, if he had no sons, would become co-heiresses and inherit his lands in equal shares. These women then held substantial estates. Isabel de Clare, a powerful English noblewoman of the 13th century, was one of the co-heiresses to the vast estates of her father, Gilbert de Clare, Earl of Gloucester and Hertford. She inherited a significant portion of these lands, which she held in her own right, bringing immense wealth and influence to her marriage. Her story is one of many that show how women, in the absence of brothers, became direct inheritors of some of the largest landholdings in the realm. They were not disinherited, they were the direct beneficiaries of the family's wealth. Even when married, women retained crucial property rights, although often managed by their husbands. As previously touched upon, the dower right in England guaranteed a widow a life interest in one-third of her husband's lands. This was an inalienable right that could not be taken away from her, even by her husband's will. Eleanor, a knight's widow in Suffolk in 1350, successfully sued her husband's family in the royal courts to claim her dower lands, which included a substantial manor house, fields, and rents from tenants. She managed these lands for the rest of her life, making decisions about crops, leases, and disputes, demonstrating her enduring property rights. This was her secure income, her guaranteed share, explicitly protected by law. On the European continent, especially in regions influenced by Roman law, the dowry played a central role, and it was almost universally considered the wife's property. While her husband administered it during the marriage, she retained legal ownership. If the marriage ended due to his death or divorce, the dowry was returned to her or her family. Caterina Cornaro, a Venetian noblewoman who became Queen of Cyprus in the 15th century, had an immense dowry that was meticulously managed and accounted for, remaining legally her own despite her marriage and royal status. The dowry was her economic safety net and often a source of significant power within her marital family. In urban centers, the picture of women's property rights was often even more robust. Many city charters and local customs granted married women the ability to engage in trade independently of their husbands, known as femmes sole traders in England or similar statuses elsewhere. This meant they could own and manage their own businesses, enter into contracts, and incur debts. For example, in medieval London, a married woman could register as a femme sole merchant and trade in her own name. Alice de Cove, a London fishmonger's wife in the 14th century, ran a successful independent business selling fish. She rented her own stalls, bought and sold produce, and prosecuted debtors in the city courts, all separate from her husband's affairs. She owned her stock, her trade tools, and her business revenues. Moreover, many medieval women were involved in the acquisition of property. They bought land, houses, and goods, often using their dower income, inherited wealth, or earnings from trade. And records from various medieval towns show women as active participants in the property market. Joan of Arc's mother, Isabelle Romee, for instance, owned property in her own right in Domremy. She managed her household and her small landed possessions. Similarly, many women in prosperous medieval cities like Florence or Paris owned houses, shops, and rental properties, which they managed and from which they derived income. These were not just theoretical rights, they were practiced realities, documented in deeds, wills, and court records. Women also held property through various legal arrangements, such as fiefments to uses, which were precursors to trusts. These arrangements could allow property to be held for a woman's benefit, sometimes bypassing common law restrictions on married women's direct control. A father might convey land to a group of trustees for the use of his daughter, ensuring she received the benefits of the property, even if her husband did not have direct legal control over it. This demonstrated a legal sophistication and a desire to secure women's property interests through creative means. The idea of women having no property rights whatsoever is a gross oversimplification that ignores the fundamental roles of dower, dowry, separate property, urban customs, and the crucial fact of inheritance in the absence of male heirs. Medieval legal systems, while often patriarchal, were also incredibly complex and varied. They provided numerous avenues for women to own, manage, and control substantial wealth, whether as single women, widows, or in many cases, even as married women. To deny these realities is to erase the economic agency and legal standing of countless women who lived and thrived in the medieval world, shaping their own financial destinies within the structures available to them.